170622 and 623 in Ray RB. So Attorney Moss, if you can please identify yourself and your readiness to proceed.
Jessica Moss for appellant. I'm ready to proceed.
And
Paula
Attorney Adams?
Yes, Paula Adams on behalf of the state, and I'm ready to proceed.
Fantastic. Attorney Adams, your volume is a little low as far as the speaker.
Is that better?
Touche. We can hear you, it's just a bit low.
Okay,
Okay.
maybe if I scoot up.
Attorney Moss, hopefully you're having a great morning. Would you like to reserve some time?
Yes, Your Honor. I'd like to reserve 4 minutes.
All right, whenever you're ready.
Thank you. Good morning, Your Honors. May it please the court. My name is Jessica Moss, and I represent the appellant RB in this matter. The purpose of a .84 hearing is to review the effectiveness of disposition, the effectiveness of treatment, the risk the child might reoffend, and to determine whether a prior classification should be continued or terminated. We are here on remand from the Ohio Supreme Court, where the Ohio Supreme Court left open that a court of appeals can determine whether there's an appropriate remedy for an untimely 8-4 hearing and to determine the issues that this court previously had determined were moot. We're asking this court vacate RB's classification due to the juvenile court's significant delay in holding the .84 hearing, as well as the continued classification from the juvenile court being an abuse of discretion. I'm going to focus primarily on the second and third assignments of error in RB's supplemental brief. As the second assignment of error, the juvenile court violated RB's due process rights when it held this .84 hearing on May 8th, 2017, which is approximately 4 years after RB was terminated from his employment.
Ms. Moss, if I could interrupt and ask you a question. The briefs kind of are like ships passing the night on this point, but you disagree that monitor time was imposed. Is that right?
We agree that the court put monitor time, but we don't agree that monitor time was an appropriate order from the court, not only to extend the length of the disposition or for when the 8.84 hearing should occur.
So you agree that monitor's time was imposed, but your position is you just think that was inappropriate for the court to impose that?
Well, if the court imposed the monitor time at a hearing where RB was not notified that the court was going to be modifying the disposition, he wasn't present for the disposition, the court did this just by entry. So while it does appear in the journal, RB submits that this was not appropriately done, that there were other mechanisms that the juvenile court could have tried to modify disposition, but that was not done in this case.
And you don't think that the language in the original order indicated, even though it didn't say monitor time, indicated monitor time?
No, I mean, it specifically did not say monitor time. There were only 4 requirements from that initial disposition for probation supervision, completing the residential program at Altercrest and following the rules and regulations of that program, as well as aftercare, and just the suspended commitment to the Department of Youth Services. So there was no mention of monitor time at that point.
So does a court have to use the word monitor time to impose monitor time?
I don't know if the court, I think the court would have to indicate in this case that monitor time was going to be imposed for him to be notified that that was going to be a condition, when the court also indicated that once he completes the orders of the court, that this .84 disposition hearing would be held. And so what
exactly is monitor time then?
So that could be a condition, and there are other cases where they specifically have ordered that. I believe it was the JF case that ordered that at the time of disposition, but that wasn't done here. So it can extend it if that's the plan for the court to be reviewed. Here in this case, the problem is that with monitoring time, the probation department had no way to effectively even monitor RB or any other individual. The Ms. Laws from probation said that not only can they not monitor them, they have no way to even enforce if there is a violation or know what conditions should be followed if somebody is on monitor time. So it's really an illusion, especially in this case, when there's nothing that can be done. It especially is not a graduated sanction of the court in looking
But
at.
wouldn't that always be the case for monitor time if the condition is just obey the law and obey any orders of the court? I mean, it's like proving a negative, right? So, I mean, what would a probation department have to do in those circumstances?
Well, even though it's obeying the law, there would have to be some other requirements. If the legislator intended for all of these cases for the end of disposition or the 0.84 hearing to happen essentially right before somebody turns 21, then they would have put that in the statute. They didn't do that here. They indicated it was the end of disposition.
When,
And so
was
that-
R&B when did R&B become aware that he was on monitor time?
I believe it was not until, quite honestly, I'm not sure. I believe that was some point later, a significant time after that order came out. There's no indication from the record that he was ever served notice of that. It was not until RB had asked for to seal and expunge his record that the court then readdressed some of those issues. So it may not have been until that point.
But
Most of
prior to
your
that, he was
arguments-
on reporting probation, is that right?
Can you repeat that, Your Honor?
Steve, prior to that, he was on reporting probation?
Correct. So that's why we're asserting that the July 29th, 2013 date should be used as the completion of disposition date. So before that, he was on probation. They were monitoring him. They were reviewing his progress in treatment. And that's the day that they actually did review all of those things when they decided to terminate him from probation.
But at some point, he would have been aware that, you know, he was no longer receiving a request to report anymore. And so, you know, I guess what it comes down to is that, you know, at some point he becomes aware that there's been some change.
He may have been
And-
aware that there's some change, but not that there was some condition that affected his ability to have this subsequent hearing, the
and so when
0.84
he
hearing.
when he became aware, did he file any objections or anything to what he is saying was a change of disposition?
No, Your Honor, but here, the 0.84 hearing, it's not on the defendant to request the 0.84 hearing. The burden is on the court to schedule this hearing, and that's the issue in this case, that wasn't done. The court didn't do this timely. So even if this court is not, doesn't look at the end of disposition date being the July date, then even if we look at end of disposition being the end of the end of his monitor time, that still is an unreasonable amount of time to have this 0.84 hearing. And he was prejudiced by this delay for several reasons. When the point of the 0.84 hearing is to look at the effectiveness of treatment, having 4 years from when treatment ended, the court isn't looking at records that are recent or have any bearing on what currently is happening for this child.
Well, see, I would have thought it might cut the other way, because if you said you had 4 years and then we have, you know, you could produce evidence of like, well, here's what I did in the last 4 years. I stayed out of trouble. I had a job or not, right? That why isn't that probative of how effective all those services were beforehand?
When the court is specifically looking at particularly those services and whether those themselves were effective, that's the problem. And here, RB lost the ability to have witnesses testify on his behalf about what his specific progress in that treatment was. There was two witnesses, or two individuals, Melissa Maurer and Shelley Baxter, who indicated that they would have provided some testimony for him, but were unwilling because it had been 4 years since he had last been seen and couldn't say whether or not he currently posed any kind of risk or what had happened since it had been so long since he had received treatment. Additionally,
Is effectiveness viewed from the perspective of rehabilitation?
it is, as well as what happened with that treatment. So the court could have even ordered another risk assessment to determine what at that time when he was terminated from probation as to what that status was.
So when you say, you know, you're talking about recidivism, right? So wouldn't, you know, isn't recidivism better viewed with the passage of time as opposed to immediately after the treatment?
It can be both ways, but here in this case, in what the 0.84 hearing is intended to do, it's not supposed to be this other extended time after treatment had ended. It's supposed to be not only at the end of disposition, but to look at that treatment. Here, to talk about what treatment was, there was numerous individuals who worked with RB and were unavailable or could not be found because of this delay in having the 0.84 hearing. There was about 8 of these individuals from probation, as well as from Child Focus and from AlterCrest. And there was additionally several other individuals who were able to be located, but didn't remember working with RB. So to have this delay in having a 0.84 hearing, 0.84 hearing has to be meaningful, and it loses that meaningfulness when you've lost this ability to have all of these people testify on what your progress in that treatment was.
Is there a case that you can share with us that would be helpful in us determining, and what you're asking us to determine, which is that 4 years from the date of treatment is unreasonable?
You're asking if there's a case that specifically cites to that? I don't know if there's a case that
Or
specifically.
that would be helpful in that determination that 4 years is unreasonable.
The Ohio Supreme Court specifically sent this back with that indication that the court can look at this. I think we have to look at the amount of time where a juvenile may be before the court, and certainly in a juvenile's short lifetime, 4 years is a significant amount of time where juvenile is experiencing a lot of different changes. So I don't know that there's a particular case because this issue hasn't been addressed, but in looking at what the purposes of juvenile court are and the purposes of rehabilitation, that 4 years was a large portion of RB's life.
Thank you.
Is there an indication in this case that this everybody just forgot about this hearing, right? Is this normally held sooner after the juvenile completes treatment?
Yeah,
Or is this just forgotten about by everybody and then they remembered it right before he turned 21?
That appears to be what happened here. This would normally be done and pursuant to statute be done sooner. In this case, it just fell between the cracks. The juvenile court did not address it. And even after saying that they were going to have a hearing, the court still didn't hold the hearing for a significant time after that. Additionally, when we look at the juvenile court continuing RB on this classification, it showed that the records from his treatment showed that he was successful in doing that treatment. He utilized those strategies. He didn't commit any other sexual offense. He was remorseful, and he not only at the beginning of his treatment, but even at the end of his treatment, continued to show that he was at a low risk. So the juvenile court's continuing classification of him is an abuse of discretion. There was nothing more that he could have done. He really checked all of the boxes for what needed to happen, and the juvenile court still decided to continue to classify him. For those reasons that we would ask this court vacate RB's classification and order that he be removed from the registry.
Thank you. Attorney Adams.
Morning. First off, I'd like to start with what constituted end of disposition, because at the same time that Counsel for RB wants to say that the monitored time wasn't properly imposed, they want to rely on that same entry to indicate that that's when official probation was terminated. Both of these occurred within the same entry. I think that's a significant moment. Also,
Ms. Adams, are you referring to the entry that said commitment is suspended on the condition that defendant obey all laws and orders of this court and shall remain in effect until he's 21?
Correct. And so substantively, monitored time was always going to be part of his disposition.
But does the court need to say monitored time? I mean, I agree that functionally that sounds like monitored time, but in terms of notice to the defendant, does the court need to explain this is monitored time, here's what it entails?
No, I think it's more significant that substantively he's told what monitored time means, and that is to obey all laws. And I think that goes to just.
But what is the repercussion? I read this and you say the commitment is suspended on the condition that defendant obey all laws. So what is the repercussion if the defendant doesn't obey all laws?
Well, and I think this case sets kind of a good example, because we have these individuals who, while their suspended commitment goes till they're age 21, that this individual turned 18 and then he violated the registration law. So you have instances where someone, even though they're on monitored time, if they commit a new offense after they're 18, then they're being treated as an adult in a whole different court. So, and I believe that the probation officer explained that a little bit in the testimony that they had in this hearing, is that at that moment in time, it was their opinion that, well, what's going to be happening across the street in the criminal matter is going to trump what we can do here in juvenile court. So there are, I think that just kind of, it's a special circumstance when we talk about.
Well, I guess then my question is, does that have any effect? And if what you're saying is, practically speaking, no one's going to do anything about it because he's going to be in the adult court system, then.
Well, in this case, now had this occurred when he was 17, that could have been different. But I'm talking about.
So what would the court have done if he had committed offenses when he was 17? Like, what would they have done based on this language?
Well, I think given the fact that he had the suspended commitment, whether or not the court wanted to reimpose some sort of official probation, or certainly they have a litany of potential dispositions that can be reinstituted at that moment in time. But it's kind of hard to look back and, like I said, age plays a part. And also what's important here is that obeying all laws and leading a law-abiding life, for him, that meant also registering. That was part of his disposition, and he didn't at that moment in time. And what RB wants us to do is look at, treatment. That's the end all be all. Everything's over after he finishes treatment. And treatment is not such a small aspect of the disposition in this case. It goes against everything. To say that everything's over after that goes against what the purpose of juvenile court is. This allowed him the opportunity to mature and apply what he learned in that treatment. And it's only fair for the court to be able to see how all that plays out before they make the determination whether or not they want to continue his classification and his duty.
Well, what about the points that Ms. Moss raises about how witnesses were unwilling to kind of opine as to his condition because it had been so long since they had him in front of them?
Well, again, those were small aspects of his disposition, the treatment and the official probation. Certainly, I think had RB complied with the registration, all of that would have played out more positively for him.
But isn't ultimately the hearing about rehabilitation, and doesn't treatment go directly to rehabilitation?
It's one aspect. If the person, while they're undergoing treatment, certainly, and I think if you look at the history of RB, a horrible upbringing, nothing stable for this individual, which contributed to his offending. If he has the opportunity to receive that treatment, and then the court sees how he does when he's on monitored time without being in a treatment facility or on his own, how that's going to apply. And again, maturity. This individual was 14 years old when he committed this offense. So maturity is going to have a huge factor for someone like that. And it's only fair for the court to be able to assess that when they're reviewing whether or not registration is going to be necessary for him in the future.
But what if he hadn't committed other offenses? I mean, I'm wondering, like, what would the testimony look like at a disposition hearing when he's had 4 years, he's not been in the system? Like, what evidence is he supposed to put forward about how he's rehabilitated other than his self-serving testimony that, I've turned the straight corner here?
Well, and that's hard to assess. I mean, that's going to be on an individual basis, and that's the purpose of these hearings, is to see no one juvenile is going to fit into a certain set of of factors here. That's why the court has so much discretion in this. Otherwise, it would be much like, the adult system. You put them in the classification and then it sticks. For this type of classification and for the whole purpose behind this to work, the juvenile court has to have that discretion, that ability to look at it down the road and see how what he has done during that disposition how he's applied that, how he is able to use that later in his life. So for us to remove little bits and pieces, from RB's cases.
Right, but my question is, how is the court supposed to do that if he's not under active treatment? I mean, in this case, you had the examples where he committed offenses, and we can all look at that. But in a case where he doesn't commit offenses, I'm struggling with what would the evidence be.
That's going to be more positive if they're able to apply what they learned in treatment and not commit more offenses. That's going to certainly be to his benefit. And that, again, that's why, and I think that it was pointed out when Ms. Moss was arguing, is that in certain scenarios that the passage of time can be a positive aspect for a juvenile to be able to point forward to that. And I don't want to negate what most of I don't want to say that this slipped through the cracks, because this was he brought before the court and he wanted to expunge wanted to seal his record. And that's kind of what got the ball rolling. The court, okay, I'm going to consider that, but you're still under a duty to register, so we can't seal your record. But let's go ahead and get the ball rolling to hold that end of disposition hearing. And then at that moment, we have the litany of jurisdictional attacks that just plagued this case from the get-go. And it's, and not only for the end of disposition hearing, they kept challenging, again, the initial classification hearing. So when we look at overall, and this would go to their third assignment of error, fundamental fairness here, RB was given multiple opportunities to make those arguments to the court, which ate up a significant amount of time in this case. So that can't all be put on, saying it slipped through the cracks or that the court was dragging its feet in this case. The court was patient, very, very patient in letting him make all of those challenges. So I don't think that should at all be held against the state in this matter. I'm sorry. Oh, okay. I'm waiting for the little lights to. So unless the court has any further questions, the state would submit on the rest of the assignments of error.
Thank you.
Thank you.
Attorney Moss.
In addition, due to this wait, RB lost the ability to go before the juvenile court for subsequent hearings, since the 0.84 hearing is the point where we can look at when he can renew requests for removal from the registry. And so that is an additional reason why this significant delay prejudiced him. Additionally,
why couldn't he have just gotten another forensic evaluation? I mean, you're saying, all this passage of time, but why not have another mental health professional or treatment professional evaluate him for the hearing?
While that may have been an option, the court also could have ordered that and didn't do so. Again, all of the treatment records, in looking at what he did during the course of his treatment for inpatient and outpatient treatment, he had all of those records talking about how successful he was. And so, and that he was at a low risk.
Yeah, but he also committed a bunch of crimes, right? After he was put on monitored time. I mean, there were several, he violated the law. So he had that going against him. And now he's trying to convince the court to exercise its discretion to take him off the registry. So why wouldn't he, it'd be in his interest to try to get another evaluation, right? To prove lack of risk of recidivism.
That may have been an option. But again, it was on the court to schedule this hearing. And even if we look at when the hearing did occur, even if we used when the end of disposition happened, or sorry, when this 0.84 hearing happened, that wouldn't even be the end of disposition. So, you know, that even though they held this, they certainly could have done it sooner and looked at all of these when they terminated him from probation. To say that what his treatment was just a small aspect of what his disposition orders require would be limiting what this was. That was a significant aspect of what the juvenile court was trying to work with him to remedy and the purpose of the juvenile court. And so that's why there was significant time where he was inpatient at Altercrest, outpatient through Altercrest, outpatient mental health treatment through Child Focus, and working with probation at that point to see how he was doing. And it only makes sense then to review at that point, you know, whether or not he should remain on the registry or be taken off of the registry. This amount of time, these people that were not able to testify on his behalf, you know, nobody was monitoring him to help say what could happen. He was only able to even have one letter on his behalf from a treatment provider, which had very positive things to say about him. And that one person actually did follow up with him after he had stopped treatment and indicated at least at that point, things were going well. So for all of those reasons, we would ask again that this court vacate RB's classification due to the significant delay in holding this 0.84 hearing and ask that he be removed from the registry.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue your timely decision, and we wish you a wonderful Tuesday.
Thanks, you too, Honor.